accepts the signature of the check. There is no dispute with regard to the check. He admits everything, my lord. And thirdly, and he did not leave any evidence. In order to support my argument, my lord, in order to support my argument, I have filed a memo of the latest Supreme Court judgment. I have filed a memo of latest Supreme Court judgment, which favors the similar nature of cases there. The case number is Supreme Court citation I have filed before this honorable court.
When did you found that? Yes.
Apps Forex Services Private Limited versus Shakti International Fashions on 14th February 2020, which is a very, very latest Supreme Court judgment, my lord. I would like to read out from this judgment in order to support my arguments. My lord, kindly take the page number, please. 8 from the citation. Paragraph number 7. The accused has admitted the issuance of the check and his signature on the check. And the check in question was issued for a second time after earlier checks were dishonored, and that even according to the accused, some amount was due and payable. There is, I underline the word, my lord, there is a presumption under section 139 of Negotiable Instrument Act, and there exists a legally enforceable debt or liability. Of course, such presumption is rebuttable in nature. However, to rebut the presumption, the accused was required to lead evidence. Here, my lord, he never led any evidence that full amount due and payable to the complainant has been paid. In the present case, no such evidence has been led by the accused, my lord. Please note this point, my lord. The story put forward by the accused that the checks were given by way of security is not believable in the absence of further evidence to debut the presumption, and more particularly the check in question was issued for the second time after the clear check was dishonored. Therefore, both the courts below have materially erred in not properly appreciating and considering the presumption in favor of the complainant. My lord, just kindly note this, my lord. Therefore, that particular point, so the trial court has erred in appreciating the evidence provided by the complainant. They did not accept, they accepted, but they materially erred in appreciating those documents. And just coming down, my lord, after the 3 lines, section, I highlighted, my lord, section 139 of this act is example to reverse burden of proof, onerous clauses, and therefore, once the issuers of this check has been admitted, even the signature on the check has been admitted, there is always a presumption in favor of the complainant, and that there exists legally enforceable debt liability. Thereafter, it is the accused to rebut such presumption by leading evidence. He never produced any evidence. And also, my lord, just I want to come to the conclusion where the appellant is clearly proves the debt liability of the accused, my lord, by looking into those documents, my lord. So my humble prayer is that please, my humble prayer set aside and convict the accused, my lord. And also this Supreme Court order has given on page 9, last page of the same citation, my lord, from Supreme Court has clearly set aside the set aside the acquittal of the accused and convicted the accused with order of fine of 10,000 and directed him to pay the appellant to 10 lakhs.
If you have to submit only about the principle.
Yes, my lord. Yeah, it is clearly mentioned here. The last paragraph, my lord. The negotiable act cannot be sustained and the same deserves to be quashed, set aside accordingly. The original accused respondent herein are held guilty for the offense under section 138 of Negotiable Instrument Act. All the original accused respondents herein are therefore convicted under section.
Counsel.
Yes,
See,
my lord.
When you are submitting a Supreme Court judgment, you only have to submit the ratio. What happened ultimately?
Okay, my lord. Okay, my lord. Okay, my lord. My humble prayer is that in support of this Supreme Court citation, kindly set aside the acquittal and convict the accused, my lord. And I leave it to the discretion of this honorable court and wisdom of this honorable court to fine him and to direct him to pay the principal amount with the bank interest and the litigation fees and compensation, my lord. This is my humble prayers, please.
Yeah. NOC is not a ground. No. See, if you are seeking adjournment, then why 1 minute?
Because the matter of the case is what my neighbor counsel my friend said on the way to the facts.
Correct. See, that you have to demonstrate in your arguments. You cannot seek adjournment and seek one minute's accommodation for you to submit about your case.
Since to make the aware of it.
See, if you are not ready today, we will list it on tomorrow or day after tomorrow. Next week, agodilla.
My lord, it is.
2017, and because you did not appear, it appears non-available warrant was issued against you. You are. No bail was granted to you. Conduct the case. Why were you fight till he argued the matter? You could have taken up some other matter otherwise.
My worship, I was waiting to get the suspect. I did not try to see. Maybe they are
not correct. I see if you do not have the copies, collect from him. Exhibits, depositions. That's all you want.
He's in the office and so that.
You do not furnish him. He says he has come on record newly. He doesn't have the copies. Don't you furnish him the certified copies of exhibits and depositions? Complaint. You have submitted to somebody else. Anyway, that is a Supreme Court judgment, reported judgment. You can collect that. Yes, learned counsel, what do you say? He is seeking adjournment on the ground that he doesn't have the copies.
My lord is deliberately dragging the matter. 2000.
When you came on record?
My lord, he is not only the first counsel. There have been so many
20
enforcement.
days time is already over.
Copy is already the application I have had on the day of day itself, Your Honor. But I didn't
My
receive.
lord, I object that one.
Learned counsel, he says, what is the difficulty for you to, on his caste, kodi copies, our caste alle kodi xerox kodli. In case vega mugiyutte.
Here, I don't know the, I don't want to, Your Honor, to further to proceed this case. I am also very-
Collect the copies from him and conduct the case. You have all the copies, complaint, depositions, exhibits. Mr. Counsel for the appellant,
My lord,
you have all the copies of exhibits, depositions.
yes,
Complaint
my lord,
copy.
I have, my lord, I have.
One set copy kodi avarge, our caste al kodi.
Hi, Swami. Actually, it's a 2013 matter, my lord. It's been dragging.
Yes,
My
we
lord.
understand. We'll
I understand, my lord. I will serve the copy. There is no problem, my lord.
Perfect. Heard the appellant's counsel.
Today itself, I'll serve you, my lord. No problem.
Sixth time on the ground that he has appeared recently and he doesn't have the copies of the records. He should collect the copies.
My lord, tomorrow or day after tomorrow, please.
1 second. Though that is not a ground to grant adjournment. Time granted on payment of cost of rupees 1,000 payable to the advocates welfare advocates benevolent fund. Okay. The appellant's counsel is requested to furnish the copies to the response counsel on his cost at his cost. List on.
My lord, 25th is fine, my lord.
Parted agide list of we have spent so much of time.
My lord, on 25th, my lord, please.
25th.
Yes, my lord.
25th. Our copies kodi ನೀವು
Now, my lord, I will do it today itself, evening itself. I will hand over to him.
25th ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ಏನಿರುತ್ತೆ ಇದರಲ್ಲಿ 138 ಎನ್ನ ಆಕ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ
Sir, my lord, all the documents are very crystal clear, my lord.
On the matter of signature, appearance is not, herself is not the owner of the property.
correct. He says the same property
Is
has
not the owner of the property. That is
whatever it may be. I can argue that correct it shows that you are aware of the facts of the case. 25th. Yes, 25th.
documents I received. I have not-
25th. 25th.
Number 34.
Much obliged, my lord.
Rajesh.
Please, my lord, appearing for the appellate, my lord. 138.
ಹೆಗ್ಡೆಯವ್ರೆ ನಮ್ಗೆ ಇವಾಗ ಏನೋ ಒಂದು ಮೀಟಿಂಗ್ ಇತ್ತು ಅಂತ ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ. ಯಾವುದೋ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಅಪೀಲ್ಸ್ ಹಿಯರಿಂಗ್ ಇತ್ತು. That was fixed.
Please, may I request, my lord, a short proceeding or tomorrow or day after tomorrow, my lord, as my lord pleases.
Tomorrow we have two parted back.
I'll take a chance
Next
day
week.
after.
Next week only.
As my
Next
lord,
week.
please.
For paucity of time. Adjourn to 2-3.
Great.
Number 35. NG Sridhar. Jagdish Court Party.
Lord, I am appearing for,
We have ಯಾವುದೋ administrative
may be taken up, my lord, next week.
next week.
35, serial number 35.
This is against acquittal. Against acquittal. Next week ಅಂತ ಡೇಟ್ ಹೇಳಿ as requested by response counsel is week after next. ಆಯ್ತು 9/3.
Number 36 subject. Number 37. Is Tushar Venkatesh.
The SPPM. ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ 37. ಇದನ್ನ ನಾವು we had not heard it. ಮಾಡಿರ್ಲಿಲ್ಲ ಅಲ್ಲ you were not heard. hearing comments ಆಗಿದೆ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಪಿಯರ್ ಆಗಿಲ್ವಲ್ಲ. ದಿಸ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ acquittal. Then their presence has to be secured. In the absence of the accused, appeal cannot be heard.
Today the first day is coming up after the
This is an appeal against order of acquittal. The respondent accused, those heard, are unrepresented. In their absence, the matter cannot be heard. Therefore, issue non-bailable warrant against the respondents. If the respondents are arrested in execution of the warrant, they shall be ಬೇಲೆಬಲ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡೋಣ ಇಲ್ಲಾಂದ್ರೆ ಸುಮ್ಮನೆ ಯಾಕೆ ನಾನ್ ಬೇಲೆಬಲ್ ಬರ್ತಾರೇನೋ ಅಷ್ಟಾದ್ರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್?
It's a proprietorship.
Proprietorship. Proprietorship. I think they shall be same thing. List down. 35. 28. 28. Non-available. So if the companies and partnership padre ಗೊತ್ತಿರೋದಿಲ್ಲ, so if it is a proprietary concern, non-available, so that they will come and file application for recalling. Otherwise they will not appear.
Number 38, Vishwanath R. Hegde. Number 38,
Representation for the appellant agent. Non-available, not necessary. If that's to the court. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, non-available ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೂ ಪ್ರೊಸೆಸ್ ಕೇಳ್ತಾರ? No. Yes. Yeah, if you have doubt, inquire in the registry also.
No, I will confirm.
Yes. Yes, next 38 and last. They were all connected. Only.